What kinds of evidence is a jury not going to be allowed to see? A jury doesn't get to see all the evidence at trial. First of all, evidence has to be relevant to the issues at trial, and what relevant generally means is the evidence tends to prove or disprove an important fact in the case. So why would some relevant evidence be excluded? There's a number of reasons, a number of rules. One very common one most people have heard of is called hearsay, and hearsay means it's a statement made out of court that's offered to prove something that's at issue in court is true. For example, if someone says, I heard Pat say that he saw Mary commit murder, that would be considered hearsay because the statement that's made out of court, and it goes directly to, assuming the court is a murder proceeding, it goes directly to an issue that the court is trying to figure out. Now, there's certain exceptions to the hearsay rule, and I don't want to make this like a law school class and go through all of them here, but in general, the judge won't let in somebody who's going to testify about what they heard somebody else say outside of the courtroom. Now, character evidence also may be excluded. So in this scenario, we're talking about Mary, who's being charged with murder. Well, if Mary has a whole bunch of violent convictions in the past, but they're not murder, they're probably not necessarily going to come in. In other words, prior bad acts can't be used to prove that Mary committed the murder. Now, the prosecution might be able to use certain prior acts to show maybe a pattern or maybe a motive, but just because somebody did bad things in the past doesn't necessarily mean that they committed the murder they're being charged for. That's the thinking. Documents won't be admitted if they can't be authenticated. And what that is suppose there's a letter about Mary planning to commit murder. Well, the prosecution would need to find the person that actually penned the letter and have that person testify that this is in fact an authentic document. Because if they just have a document without somebody to authenticate it, it's not going to come into evidence. In a number of jurisdictions, there's different kinds of privileges, and privileges basically mean when you're talking to somebody about something, that person you spoke to doesn't get to testify about it in court. So a very common one is the attorney-client privilege. So if I'm Mary's lawyer and Mary comes to me and says, hey, Tom, guess what? I committed murder and I'm guilty, but I want to hire you to defend me. Well, I'm not going to like that very much, but I cannot disclose that to the court. The court's not going to put me on the stand and say, did Mary tell you that she committed murder, and have me testify that yes, she told me she committed murder. That's considered attorney-client privilege. So there's also something called the spousal privileges. When people are married and they talk to each other, generally that is privileged as well. You're not going to have one spouse testifying against the other. Again, there's some exceptions, and we're not talking family court, we're talking criminal court here. Sometimes there's also a privilege about, sometimes many times, if somebody has a psychotherapist and they're going to the psychotherapist, and in this case, if Mary goes to her psychotherapist and says, hey, you know what, I feel kind of bad, I killed Pat, can you give me something for that, or can we talk it through? The court's probably not going to be able to put the psychotherapist on the stand and have the psychotherapist testify that in fact Mary admitted to murder, because there's a privilege between a patient and a psychotherapist. Now, even if there is evidence that's relevant, it's important to the case, and it's admissible because there's no specific rule that keeps it out, the judge still has discretion to keep the evidence out in certain circumstances, easy for me to say. So when would this happen? Well, if the judge would believe that the evidence would be confusing to the jury, or the judge would believe that it would be misleading to the jury, or if it, in quotes again, unfairly prejudices the defendant. Again, this is a very fact-specific scenario, and so the attorneys on either side are going to be arguing about this prior to trial. Often this is done in forms called motions in limine. So again, this is just a brief overview of what evidence may come in or may not come in. But if you are involved in litigation, pay close attention to the battle between your lawyer and the other side, as the evidence that's excluded from the trial, the evidence the jury doesn't get to see, can be, in many instances, almost as important as the evidence that the jury does see. So, hope this helps a little bit. Thanks very much for watching.